If you're watching this, it's being posted on Friday, June 6th. I'm Kristina Rex, here with Katherine Loftus, our legal analyst. I have a lot of disclaimers to make this morning, one of which being I'm in the passenger seat of a car. So you'll notice that I'm in a moving car, and I'm sorry, but I'm in the passenger seat. Also, we are recording this on Thursday, June 5th, when there is no court today, because I will be out of state tomorrow. So we're just changing up the schedule a little bit.
Well, lucky for
There's all
you,
the
I
disclaimers, I
can
think.
talk and talk and talk. So
Perfect. You will do most of the talking while I'm in this car. Let's start. Let's start at the beginning of the week. We're gonna just go through what happened this week. It's been the defense's case, which started last Friday, but continued on Monday, and started with a friend of Michael Proctor. So why don't you just tell us? Well, I'll do the debrief on what happened. Basically, a friend of Michael Proctor's was called to the stand. The judge gave the lawyers permission to basically bring Michael Proctor's text messages into evidence via this friend of his. And then why don't you take it from there? Tell us your thoughts on how this.
so Mr. I think it was Diamantis. I might be pronouncing his name wrong. So he's a friend.
No, you're right.
Michael Proctor has a group text message with a bunch of childhood friends, like who have been, years and years, 30, 40 years. And in the federal investigation, these were the text messages that we heard about in trial number one. In trial number one, we heard Michael Proctor testify to these, himself through cross-examination. In trial number two, what happened instead is because Attorney Brennan didn't call Michael Proctor himself, thereby sort of precluding the defense from cross-examining him, the defense decided to introduce these texts through one of the individuals on the text message chain. He was up very briefly for the defense, and essentially like a packet of text messages was admitted to the court. And then David Yannetti sat down and said that's all he had, which was a bit surprising, if I'm being totally honest.
Yeah, can you talk about that? Because he didn't even read the texts.
No, and Kristina, even still, to be honest, I'm not really sure what the strategy was with that. I don't know if they thought Attorney Brennan wouldn't read them, or they would just kind of let them go in so the jury could see them on their own. And, I'm really not sure. I thought that David Yannetti would either have the witness read them, or he would go through them himself. And the concern, it's, because it's not like, regardless of who reads them, the substance of the text messages are still the same. However, allowing Attorney Brennan to sort of guide, the tone of the reading of it, the inflection, which ones he focuses on, which one he doesn't, and then allowing him to sort of further those questions about what kind of text did you not see, about framing, about planting, things like that. So overall, I mean, he was a very, he was I suppose, a necessary witness to get the text messages in for the defense. I think it was a little bit of a miss in how they presented it, because they could have had a lot more control. If the Attorney Yannetti read them, I think they would have been a lot more lively and maybe had a little bit more teeth to them. And so it may have fallen a little bit flat from Hank Brennan, but overall, this is really the first time now that the jury is hearing, really in depth about what Michael Proctor, this former, fired state police officer, Michael Proctor, what was he actually texting about Karen Read?
And this feels like a good moment to mention that the defense has requested that the judge basically give them the ability to make a missing witness argument and a jury instruction for Michael Proctor, Brian Albert, and Brian Higgins. So these three men who were not called by prosecutors, who it appears are not going to be called by the defense either. Can you just explain for our viewers kind of what the goal is there?
So what the goal is it's essentially what we call an adverse inference instruction. So they want to ask the judge that at the close of all evidence, that she instructs them that because Michael Proctor, let's just use Michael Proctor for one as an example, because Michael Proctor wasn't called, then that the jury can draw that adverse inference that it would have been harmful to the Commonwealth's case and potentially helpful to the defense. Now, they don't have to show, it's called a missing witness instruction, which is a little misleading, because they don't have to be missing in terms of, we can't find them anywhere, they're not around, that kind of thing. they have to be available to have been called by the Commonwealth, likely to be friendly to them, and potentially give testimony that otherwise would have been helpful to the defense, harmful to the Commonwealth, and there can be no tactical or strategic reason for the party that you're asking for the inference to be drawn against, could not call them. So I do think that out of all three, I don't think there's any chance that they get that instruction on Brian Higgins and Brian Albert. I mean, there's barely any foundation that's been laid for it, and I don't think you can meet the prong that these people would be that beneficial one way or the other. But I think Michael Proctor is a fair argument. I mean, what Attorney Brennan has done in sort of tactically deciding not to call Michael Proctor, he's forced the defense to come up with a different way to deal with him. And now they don't want to call him because they then have concerns that this potential rehabilitation and, easier to point the finger at the boogeyman. So we haven't seen opposition or a response from the Commonwealth relative to the request for instruction. So it'll be interesting to see. But out of the three, I think there is a chance that they might get it on Michael Proctor.
So my next question was moving into a person who I don't know how substantive the testimony was, but was absolutely a very dramatic moment in court, which is Officer Kelly Dever. She's currently a Boston police officer, formerly a Canton police officer. My understanding of her testimony is that she told federal investigators years ago that she saw Brian Higgins and former Canton Police Chief Ken Berkowitz for a long time, but then she recanted that because she said she actually left work 3:45 long before Karen Reed's car was ever there. That's the background for her taking the stand. Now, can you just take us through kind of what on her thumb?
Sure. So Kelly Dever is an interesting witness. So she, like you said, she was former Canton PD and then is now Boston PD. It seems to be that the very first time she was interviewed was by the federal investigators. It doesn't seem that anybody talked to her before that. So we're talking probably 18 months at that point. The incident's January 2022, and she's interviewed, I believe, in August of 2023. And based on the testimony, and it was a little bit difficult to glean even through the questioning from Alan Jackson and the cross from Hank Brennan, because she was so combative on the stand. She didn't want to answer even like the most basic of questions. But what she allegedly told the federal investigators was that she saw Chief Berkowitz and Brian Higgins in the Sally Port when the car was there for, I think she's called it a wildly long time. Now, before trial one, it appears that the defense wanted her to testify as to that statement. And she then told the defense that that wasn't her memory anymore. I mean, we don't know what the conversations fully were between the defense team and she, but what she said was, during that conversation, you threatened me with perjury. You wanted me to tell a lie on the stand. She kept calling it a false memory, which I don't think that was the word she should have used, because number one, that gives her problems potentially as a police officer in future cases where she testifies, because you get to bring that up as a defense attorney and say, like, but didn't you have this case where you thought you really thought you knew and then you didn't know, and so which one is it? The question that ultimately it comes down to with Officer Dever is, there's two possibilities. One, she actually saw Chief Berkowitz and Brian Higgins go into the Sally Port while the car was there, and she's now changing her story and saying she didn't see that at all. Or she saw them together potentially at the Sally Port, but it wasn't when the vehicle was there. And it really wasn't clarified whether, are you changing your story like you never saw them, or are you saying that you saw them at a different time and so you couldn't? I mean, the what I got from it, it seemed like, okay, it seems like you saw them, right? I don't think you would make that up, especially to federal investigators. But if you learn later that it was at 3:45 or before when you got off of work and you know that the vehicle didn't get there until 5:30, and you realize like, oh, I told them, I saw them go into the Sally port when the car was there, and now I know that that was wrong. I mean, you have an obligation, especially as a police officer or an attorney, anyone, to correct that. But it wasn't clear. Nobody really, I don't think anybody really clarified that from either the defense or the prosecution. They sort of just like left it out there. I think both of them, when she was on the stand, she was so combative to both parties. I think they just wanted her off.
It seemed like, and tell me if you would agree with this, it seemed like a huge risk to call her. And then I'm just not even sure if her testimony benefited anybody. Like, if you're a juror sitting there, what do you think about this?
Well, I think I'm not sure that it's always a risk to call a witness that you don't really know what they're going to say and that you haven't prepped with, that you haven't talked about. And that's probably a lot of the reason why Attorney Brennan didn't inquire further, because, one of the sort of rules as an attorney is like, don't ask questions that you don't know the answer to, or at least that you don't know which way she's going to go. So I think maybe that's why some of his question was more limited, but ultimately, I'm not sure that it's as persuasive to the jury as maybe those, in the online sort of so the online spectators, because it's a big stretch from, okay, we've heard sort of tangentially in the Commonwealth's case in chief through cross-examination about Chief Berkowitz and Brian Higgins, but I mean, really very, very minimally. That the defense hasn't said, hey, we think they did it. They just have sort of skirted around. Could they be in this area? Were they around the Sally Port? So I'm not sure that the jury is going to understand what the defense was trying to even do with that testimony.
Okay. I feel like I do want to get through every witness this week, so we'll keep this one quick because we have talked about this woman for 2 years now. Dr. Russell, dog
Yeah.
bite expert. She's testified so many times now in voir dires in the first trial and this trial. Uh, just what was your overall takeaway this time?
I mean, she seems generally all the same to me. I think she's a very likable woman. She's clearly educated, clearly has, the credentials. She's been a physician for a long time. She's a police officer previous to that. I mean, she seems pretty steadfast in her belief based on her analysis that these are in fact dog bites, that she has the expertise and sort of the experience, treating wounds in the emergency department as well as a medical examiner, that she can confidently say that these are in fact dog bites. I think that Attorney Brennan did a good job cross-examining her. He really questioned what her methodology was. Like, was there actually any data that she relied upon? She talked a little bit about, that she sort of evaluated different options in her head, but didn't write a report. So, I think she helps I think if you lean towards the sort of the defense theory, I think that there was no collision, that something else happened. She provides an alternate explanation to John's injuries. But I also think that, she might not be as credible of an opinion ultimately as, maybe somebody who dug a little bit deeper into it. She obviously reviewed everything, but she didn't look at the impressions from the dog. She didn't deter, the fact that there was no dog DNA, things like that. But overall, I think she did fine. She was definitely helpful for the defense. Everyone so far for the defense, I think, has been able to provide them with what they were looking for.
You just led into this. There's no DNA, dog DNA. That introduction of evidence caused the defense to ask, and I quote, vigorously for a mistrial with prejudice,
That's
which
right.
got denied. Why ask for a mistrial at that stage? And so a mistrial with prejudice would mean the case can't be brought again. So that would be a
Right.
win for the defense. But
Right.
I mean, is a mistrial what the defense is looking for?
Well, I mean, I don't think you ask for a mistrial unless you're looking for a mistrial. So it's surprising that this late in the game that they would move for a mistrial on testimony that, quite frankly, I'm not sure is really that harmful to their client. I mean, you have a doctor that says, yes, okay, there was no dog DNA. I evaluated that, and I still think that a dog bit him, and this, this is why. So, I think there's a sort of the fact that the dog DNA was brought in. Let me back up a little bit. So the legal basis that the defense was arguing was that essentially this was impermissible evidence because the Commonwealth didn't introduce it in their case in chief and chose not to, right? So they chose not to call the person from the California lab that tested it, said there was no dog DNA, that kind of thing. And they were called the first time. And if the defense would probably be correct if Attorney Brennan had attempted to get that information into evidence through a witness improperly. So if there was somebody that didn't have to do with dogs, and you're just asking them, maybe it's a police officer or somebody else, what that would mean is that the Commonwealth was really trying to skirt the rules, that we didn't want to put it in our own case in chief, but we kind of want to drop the bomb on it in cross-examination of one of the defense's witness. The problem with the argument is that the defense's expert is being called specifically to opine that a dog bit John O'Keefe. And so to make the argument that asking whether there is dog DNA or not, and whether that's been evaluated as part of forming your opinion, to me is clearly permissible within the scope of cross-examination. I've used this example a couple of times, but if you think about the converse, that if the Commonwealth was saying that this is a dog, would the defense be able to ask, but there was no dog DNA, did you use that as part of your evaluation? Of course they would, because it's cross-examination. You're presenting the witness, you're presenting this as her opinion. She's evaluated this evidence as part of her opinion. She testified to it previously in a voir dire. So I think the decision was right. And the fact that she denied the mistrial and allowed Attorney Brennan to continue that line of questioning. And I do think it's an indication for the defense. I mean, my gut reaction was the fact that they're asking for a mistrial this late in the game shows me that they have concern that she's going to be convicted of something, or at least, we don't know, but that there is maybe more of a likelihood than the first time that they thought, and that, they're sort of looking for a potential avenue out.
Makes sense. Okay, we have three more witnesses. Let's really quickly do Sergeant Nicholas Barros of Dighton Police, who testified that he was there when the car was towed from Dighton and he saw a dollar bill size piece of taillight missing, but that he said absolutely was not the amount missing based on the Sally Port picture. Was that a bombshell moment? I think there was a lot of back and forth on this. Some people were like, oh, that blows up the state's case. But then on cross-examination, that kind of went in the other direction.
I think it's similar in many ways to a lot of the witnesses, is that they do really well for the side that they're being called on, and then during the cross they're able to, and that's pretty typical of witnesses, that when you call your own. So obviously the way he testified for the defense was beneficial to them. He says that he saw this, like you said, this dollar size hole, and that when shown the picture of the vehicle in the Sally Port, said absolutely not, it didn't look like that. But then on cross-examination, I think it was one of the last questions, Attorney Brennan ultimately shows him the video and the still picture from the driveway and says, what did it look like this? And he says yes. So listen, it's one of those things that, again, he comes off as, completely credible. I am sure his memory is, I don't think he's not telling the truth. I'm sure that's what his memory is. Whether that's an actual representation of what it looks like that day, we don't know. And the jury uses all these pieces of evidence to say, maybe lead them one way or the other. Like you said, for some people will say that's such a big piece of evidence, it has to lead you towards the defense. Others might say, well, he wasn't asked about it for 2 years, and and so how strong is his memory? So those are one of those individual evaluations that the jury ultimately does for really each piece of testimony.
Okay, and then the last two witnesses so far were Lucky Lochran, who's a plow driver who says he did not see the body on the lawn despite driving by at least 4 different times while plowing that night, and then Karina Kolakithis, who was out at the bar and basically just testified that she was with Karen the whole time she was there, and she and John seemed happy and loving, and Karen didn't seem drunk. What do you think was the effect of that that day of testimony for?
So I think, I think Lucky was very good for the defense, as he was, the first time. Basically, he says, I didn't see a body. I went by multiple times. I saw, I know the route. I'm familiar with the area. I'm familiar with um, sorry. I'm familiar with the Albert's residents. He grew up in the town. He knows all these people. And, he says, every time I drove by, I didn't see a body. So that statement in and of itself certainly helps the defense. Again, like I said, with every witness, on the counter to that and cross-examination, which I thought was at least for me, and I don't know how everybody interprets that, but what a very effective line of questioning from Attorney Brennan was asking him about that dumpster, right? Because right. So theoretically, he drove by that dumpster. If he drove by the Albert House 4 times, he drove by the dumpster 4 times. And then when asked, he said, no, I didn't see a dumpster. I don't remember a dumpster.
Well, not
But
only that, he said I wasn't looking for a dumpster.
right, right. And so, it really goes to, again, I hop on this idea of like memory, but I think that you sort of as lay people, we just think that if somebody has a memory of something, then that means that's what actually happened or what they actually saw. But there's so many factors that come into play. It's always someone's memory of a specific instance happening is always going to be subject to some critique, potentially even more so the longer removed you are from the incident, right? So, the question ultimately becomes, did he not see the body because there was no body? Or did he not see a body because he wasn't looking for a body? Just like he didn't see the dumpster because he wasn't looking for it. So again, weighed with the jury. I think Miss Kolakithis, I don't know what she really brought to the testimony. It's laid a little bit of a foundation. She's really the first person to, for the most part, kind of like attest to who Karen was. A little bit Jen McCabe did, but from the defense perspective, talked about their interaction that night, that she didn't seem intoxicated. But ultimately, I'm not sure what purpose or what benefit she really provided to the defense. And she was probably unnecessary to call, but she didn't hurt or harm.
So here's my big wrap-up question of the week. Which, first of all, thank you to everybody watching for bearing with my unusual setup today. My big wrap-up question of the week is, so we know Karen Reed says her team will wrap up next week. We know that there's some heavy hitters coming. ARCA, the crash reconstruction, is still have to testify. Having seen the defensive case now, or at least the majority of it, what do you expect a closing argument will look like from the defense this time?
I think they're not going to be pointing too many fingers. I mean, I think what they're going to be doing is, instead of saying, this is what happened, because in trial number 1, they presented like an alternate theory. They didn't do that this time. And whether that was ultimately, their initial strategy, or they had to change as, testimony developed and the Commonwealth presented their case. But I think what they're going to do is say, listen, you have a police lead investigator who's been fired. You didn't even hear from him from the Commonwealth. What you did hear was, how he treated the defendant, how he spoke about her, the fact that he basically thought she was guilty, and, open and shut right off the bat. You have the Canton police who, are collecting evidence with snow blowers and red solo cups and stop and shop bags. And we have, this somebody who says it was dog bites. We have somebody over here who says it couldn't have been in a car. So what they'll try to frame is, you have all these other scenarios that the police didn't even look at. And because they didn't even do their job by looking at all these scenarios, that you have to find her not guilty, right? Because the substandard police investigation so greatly affected the overall case as a whole, that you can't possibly find her guilty. So I think that's probably going to be a big shift from, the real like pointing the fingers at individual people that they did in trial number 1.
I think you're right.
Well, thank you.
We'll see. And we'll be back. Oh, we'll be back next week, maybe. If there's a wrap up and a verdict and whatnot, you will see us much earlier than next Friday. So
That's right.
I'll see you soon. Bye. Thank you.
Thanks, guys.